Buckle up, guys. Today we are diving straight into a courtroom case that wastes no time setting the tone. Right from the opening seconds, the narrator frames this plaintiff as someone who lives for lawsuits, and before we even reach the docket call, we already see.
Based on that information.
Oh, she's having a meltdown. Oh.
Mr. Quadron, let's not comment on that there.
Alright, guys, this is where procedure immediately turns into conflict. The defendant calmly explains he never received proper notice of the amended claim, while the judge checks the record line by line. What should be a routine confirmation suddenly becomes a credibility test. The defendant.
Right, we're here in 24S000235. We have the plaintiff Jenny Kiriconi present. We have the defendant Justin Quadron present. Sir, are you, do you own Affordable Land Care LLC?
Yes, ma'am.
All right, he is the owner of the other named defendant, Affordable Land Care LLC. So I see that there has been an amended claim filed in this matter. Let me go ahead and make sure that all the parties are aware of this new amended value. Have you received that, sir, the amended claim?
I haven't received any paperwork, no.
Well, how do you know to be here today, sir?
Well, I received paperwork previously, like months ago, or weeks ago. I'm sorry, I'm busy, so I lose track of time. But I haven't received paperwork for this court date today. I called you guys at the district court and followed up on I looked up the dates and I was just following the trail, but I haven't been served proper paperwork yet. No.
Well, I have right here, and I just want to make sure that everything is correct. I have right here that a proof of service. It says here that you were personally served on February 2nd, 2025 at 1:30 p.m. and that you were
And
served.
that was on a Sunday.
Yeah, I'm not
Yep,
quite sure.
that's the one I was served, but there were no court dates on that paperwork. It didn't say, "Hey, you're at this date," and it didn't say what. There was no exhibits. There was nothing attached to that. I didn't know what I was being sued for other than what was on that paper.
1 second. Ms. Kiriconi, did you file proof of service on the amended claim?
I attempted to, Your Honor. And in fact, yesterday I delivered to the court proof that I engaged Emerald Legal Service down in Eugene, and they attempted many times to serve Mr. Guadron, and that he refused to open his door on many occasions. There is something that they call a proof of due diligence as well, along with the other document.
Now watch closely, because this is where the judge takes control. The plaintiff admits she attempted service but failed to file proper proof, and the court immediately shuts the momentum down. The judge reminds her that experience with lawsuits cuts both ways, meaning ignorance
or by substitute service. So if they have been attempting to do it, then you would need to just serve him by certified mail, because at this point we don't actually have proof of service of the amended claim. I will agree. I do accept. All right, but that hasn't been filed, ma'am. I don't have a proof of service on my end. I see that you have that form, but I have a defendant here saying that he didn't receive the amended claim.
He did not receive the amended claim, Your Honor, because he has refused to open the door to the personal service representatives trying to serve the amended claims notice.
And I hear you, ma'am, but unfortunately he does need to get that serviced. So you can do that by certified mail, and that would be sufficient. He doesn't need to be served by an individual then.
When I have done that before, he refused it. He refused it to pick it up for over 30 days. That's why I used a service to inform him of the February 2nd one.
Well, you know, it can be left in a mailbox too.
I will attempt again, Your Honor.
Okay, all right. So, sir, you are here. You followed the trail of dates. You are now aware that you are going to be served an amended claim.
What address is she mailing them to? Because I have moved. I'm a single dad and I had to relocate to be near my kid. So
Sure,
she
Ms.
might be mailing
Piraconi,
them to the wrong address.
what's the address that you're trying to serve, please? Ms. Pir-
It should be on the paperwork from the service, Your Honor. I do not have that paperwork right in front of me.
I don't have a proof of service for the amended claim. For the small claim, it is,
Yes, you do not have proof of service for the amended claim because the defendant has refused to open the door to Emerald Legal Service of
ma'am,
Eugene.
I understood.
Okay,
And I
okay.
understand.
And I
just-
understand he can also refuse to pick up the registered mail, certified mail. I will attempt to do that again, Your Honor, at his Eugene address.
That is not what I'm asking, ma'am. I'm trying to find the address to tell him. And I said, I don't have one for the new
All
proof of
right,
service. I will look at the old proof of service. And I'm asking you, is that the same address you are trying to serve?
No, Your Honor. That address is open.
Well, Eugene, Oregon.
Eugene,
974.
Oregon.
Is that your address, sir?
Yes.
Okay. All right. Well, you're now put on notice that you are trying to be served this amended claim. At this point, there's really no reason for you not to accept service of it because we do have proof of service on the small claim. I don't think there's any difference. So the original claim is asking for $6,000 in reimbursement, and the amended claim is asking for also $6,000. So not an additional, but the same amount.
Okay.
So
what does it say? What are the accusations?
well,
What
I
is
need you to accept that. It says right here, cost of permit and inspection costs to remediate items, failing inspection, post to complete work left undone, including labor and materials, cost of cleanup. So,
Well,
sir,
can we avoid time and just enter court now? So we
no,
can just, or
I
do I
don't
have
have
to wait
time. I
for
have
her?
a trial in 5 minutes. So
Okay,
today's
so I still
purely
have to wait for her to serve me?
yeah, so she needs
Okay.
to serve you, but we can set up a trial date right now. I just want you to know there's no point in avoiding it because she's already served you on the other one, which I could have trial
Yeah,
on the other claim.
I'm not avoiding anything. I'm a
Okay.
business owner and I'm working and
Okay,
I apologize about the inconvenience, but I don't even stay here half the time. I'm between two states.
okay,
So they're just not catching me when I'm home.
okay, all right, but I just wanted to give you a heads up. It's not like
Yep.
it's a bigger amount. It's just, I think she amended the description of
I
why.
also want to argue that the amount that she's asking for is higher than what a legal ability to sue for an LLC in the state of Washington. Based off my research, the highest amount is 5,000.
That's only if
But-
she's an LLC. You can sue
Got
a
it.
business up to $10,000, but if you were to sue her, you could only ask her for $5,000.
Alright, guys, this section shows how quickly frustration replaces logic. Address confusion, refusal accusations, and claims of evasion start flying, but the judge keeps pulling the conversation back to reality.
All right, good afternoon to both parties. If you could please unmute. Mr. Guadron, if you could please unmute, take off your hat and just drop the. Mr. Guadron, what is your background, sir?
It's a picture of the kitchen that we did some work on, and since this court case we had with you, I found out that it's being broadcast on YouTube and over 37,000 people are watching us. So I figured I'd put that up there so we can.
All right, sir. I did see an exhibit you submitted, and I'm aware that this is now likely being streamed on YouTube. If you could please take down your background, I don't appreciate me being broadcast in the background in a picture like that. Thank you, sir.
Let me see if I can figure out how to do it while we're working here.
I'll wait until you can figure it out, sir.
Does that work?
That's great. Thank you, sir. All right, so we're here in case 24S235. We have the plaintiff, Jenny Quiriconi, present. We have the defendant, Justin Guadron. Are you the owner of Affordable Land Care, sir?
Yes.
Okay, the owner of Affordable Land Care. So it looks like an amended claim was filed, but as of today, sir, $6,000 is being requested by Ms. Quiriconi against you. Are you aware of that value?
Yes.
All right, sir. So, sir, you keep popping in and out. I don't know if you could just stay in the camera, please.
I'm sorry. I'm at work.
All right. Well, this is a trial. So
Yep.
I apologize that you're at work. You're just going to have to take some time off to handle this matter. All right, sir. So going forward, this is a trial. Ms. Quiriconi is going to go first. She is the plaintiff in this matter. I'm going to let her go first, present the evidence that she has for the $6,000 value she is seeking against you. If she has any witnesses to call, she can call them forward, and then we will listen to her side of the story. When she's done, I'll let you tell your side of the story, sir. I ask that both parties do not address the other, that they only address me. If there are any questions, just to me, let's try to keep this amicable. I don't want this to be a contentious situation now that you have brought to light that most people on YouTube like to watch Ms. Quiriconi's matters. So let's just keep this very amicable, please. When you're done, I'll go ahead and offer my judgment in this matter. Are there any questions in regards to any of this going forward?
Yes, Your Honor, I have questions.
What's your question, Ms. Quiriconi?
Your Honor, what makes you think, as you stated, that people are watching because of my matters and not because it is your court?
That's true. It might be my court.
Your
Any
Honor,
other questions?
are you aware that because that your court has been monetized on YouTube, that I have been subject to harassment by
It's not monetized. How is there any monetary financial gain from this?
the people who stream YouTube channels have paid subscribers?
What does that have to do with me, Ms. Quiriconi?
I am just stating facts regarding your channel being monetized.
It's not a channel. I'm a government employee sitting in a courtroom. This is not a YouTube channel. This is a Zoom trial.
This is true, Your Honor. And people on YouTube are monetizing your court by paid subscriptions to their channel.
The defendant explains relocation and work obligations, while the plaintiff insists he's avoiding service. The judge's patience thins as she forces clarity instead of theatrics. By the end of this stretch, everyone understands the claim amount, the amended language, and that delay tactics won't change outcomes. This is procedural chess, and emotional moves are losing pieces fast.
The picture of my kitchen in his background.
All right. Mr. Guadron, please take it down and make just a neutral background. That is an exhibit that has been submitted, and I will go ahead and review it at another time.
Can you see? I just want this exhibit that's in my background is pertaining to the case. Wasn't able to give it to you in the photos. I wanted
Okay,
you
well
to
then
see
please take
this
it down. Please take it down.
because it goes against one of her allegations.
All right, so you're going to have to just testify against to that verbally at that point. Please take it down. Thank you, sir. Anything else, Ms. Quiriconi? Because we need to begin.
I understand.
All right. So we're going to go ahead and begin. Please raise your right hand. Do you swear to tell the whole truth during this proceeding?
I do, Your Honor.
Please state your full name and spell your last name for the record.
Jenny Quiriconi, Quiriconi.
Thank you. Please begin with your testimony.
Your Honor, last year, I contracted with Justin Guadron and Affordable Land Care to have my very small 9 by 10 kitchen remodeled. I paid my invoices, and within the exhibits, you will find representations of my checks that he accepted in full payment of the first 2 invoices generated by him. There are no details of how much labor might be required in hours. And in fact, I did not ask him at any point for documentation on hours. And that is one of the questions that I have for Mr. Guadron, is if he can supply documentation for the number of hours and the days that he worked.
Quiricone, I apologize. Mr. Guadron, this is a trial. Please take off your hat. Please do not drink beverages, and please do not eat any food. This is a serious matter, sir. Thank you.
I'm sorry.
Ms. Quiricone, please continue.
Thank you, Your Honor. Because of the nature of the work, plumbing was required. I have since found out that while Mr. Guadron is a plumbing contractor and a general contractor, he is not a plumber. And from the very beginning, he put himself forward as a plumber. A plumber must have that qualification through Labor and Industries. Mr. Guadron is a plumber trainee, and as a plumber trainee, he is required to have supervision on site for his work. To my knowledge, he never had supervision on site. Within the paperwork is who is supposed to be supervising him. I was unfamiliar with that name until I started looking into his background.
This is where the case turns openly uncomfortable. The moment YouTube is mentioned, the plaintiff pivots from legal arguments to personal grievance, accusing monetization and harassment. The judge immediately draws a hard line, reminding her this is a courtroom.
In one of his own text messages from the very beginning that he and his partner are coming by. Now, there is some paperwork that says he has a partner named Patrick, but there is no last name, and I never met anyone named Patrick. I never heard their name, nor did I ever hear the name of the person who was supposed to supervise him. I was not on site the entire time that the plumbing work was being done. However, when I was here and plumbing work was being done, there was absolutely no supervision whatsoever. Mr. Guadron claims that there were, according to his document, unexpected circumstances. But his document also says that his labor is warranted for 1 year. That year is not yet up, Your Honor. I have had an estimate done of what it will take to remediate the items in my kitchen that are substandard, do not pass inspection, and I have requested be fixed by Mr. Guadron. He has refused communication. He has done shoddy repair work. Behind me are 2 full tiles of flooring that were available to properly repair the floor. Instead, he put in a little plug in the flooring that has a hole all the way around it, and in the center, they go straight through the subfloor and into the insulation. In the picture showing that, there are numbers 1 and 2. 1 shows the pipes passing from under the cabinet and into the floor. Plumbing regulations require that something like this item, I believe it's called an escutcheon, this one was made in 1914, go around those pipes and secure them to the floor. This prevents my plumbing from passing inspection. an inspection for which a permit was never obtained. If Mr. Guadron is a plumber and a plumbing contractor, he ought to have gotten the proper permit to do the plumbing work. He did not acquire that permit. I do not know if he got permits for remodeling. I have not checked. I never saw one. The only permit I ever saw was for electrical, and I paid for that. If you notice in the picture where the floor has been repaired, you will also see at the back of the wall, there are no baseboards. This means should any pipe burst, should there be any kind of leak whatsoever, that water is going to go down there at the base of the floor, ruining not only the sheetrock behind it, but possibly the underlying subfloor, the insulation, and even the foundation. It can contribute to rot and mold. In addition, insects can come up through there. Food items can get trapped in there, so it creates a very unsanitary condition. This ought to have been fixed. My requests have basically been
not a content dispute. Meanwhile, the background image argument escalates into a public scolding. What should be evidence becomes spectacle. This segment perfectly illustrates how credibility erodes when focus shifts from facts to ego. The judge tolerates exactly none of it, and the imbalance becomes impossible.
Mr. Guadron's paperwork, where page 1 refers to a partner. I don't know what partner he's referring to, whether it's Patrick or whether it's the one and only person I ever saw here on site, Zach. I never knew Zach's name. I don't know how many employees there are. He wanted me to use my truck for hauling things. They left all the stuff behind. I took care of it myself. On one of these pages, the date is hard to tell, but on April 17th, that was when the electrical was done and when the inspection. The next page, the conversation about the shed and the garage, and he's been busy helping a friend move. Or I don't know when that conversation was. It's not identified with any kind of date, or nor is the next one about when he's going to be home, when I'm going to be home in a few minutes. He's apparently not ready to, he's not in a hurry. He's concerned about my squatter that I had. In the end of August, he lets me know when his employee, who he misspells the name, I don't know whether it's Z-A-C-K or Z-A-K. I let him know when I was in the hospital. I let him know that there was a hole under my kitchen sink, under my kitchen, in my kitchen, under the cabinets that needed to be repaired. I had the tiles then. The labor costs are so expensive. Never, ever, ever do I get to see what the labor charge is. I have talked with a couple of plumbers since, and I know that a trainee generally makes much less than a journeyman plumber. I was basically charged $4,000 for very little work. I don't know if it even took him 10 hours, which would be $400 an hour, which is far above what a journeyman plumber would cost. Then he introduces some totally unrelated to this case information.
All right, Ms. Kuraconi, you seem to be spending a lot of time going through his exhibits, which is fine, but
okay.
I think that what you miss is where are you getting $6,000 from?
I believe I have a document that I supplied to you for the $6,000. It would be including the $35 fee for court, $46.80 for the permit for plumbing, $9.68 for the first notice by certified mail, $160 to Emerald City Legal for skip tracing and the attempt to file, $10.10 for the second notice by mail, $80 for attempts to serve, $362.68 to get all of my doors rekeyed because employees Zach and owner Mr. Guadron never returned my key that they were in possession of. I didn't feel safe. I better get my house rekeyed. Then there is the $4,983.08 estimate for remediation. I could only find one firm that was willing to take on this job, Your Honor, which is why there is not a second estimate.
Ms. Quiriconi, this piece of paper where you typed up yourself, this is an estimate from a licensed company?
Yes, and that is there.
Why didn't you send me the actual email from the licensed company as opposed to you just typing it up yourself?
Oh, it should be in your documents, Your Honor, from Heritage.
Okay, let me look for Heritage.
Your Honor.
One second.
Can I-
Let me just try to find this Heritage. Ms. Quiriconi, please hold up the Heritage document.
It's 2 pages.
Sure.
Here, oh, maybe it's 3. And they actually show their labor cost per hour. Unlike Mr. Guadron, who never showed me a thing.
All right, ma'am. I don't see anything from Heritage. Oh, here it is. Okay. Let me go ahead. So it's 2 pages.
One of them has a back on it, I believe.
All right. So I think that a big statement of yours is that none of this would pass inspection as to why you're looking for another construction company to come in and remediate what you think would not pass inspection. Could you please turn my attention to where the inspection report is, that none of this would pass inspection?
They will not provide that, Your Honor.
So you're saying that
I
they
can tell you
inspected your house and they wouldn't provide an inspection report?
that is correct. They will give me a pass report, but they did not supply a due